Yo, what's up, my people? On this episode of Vent, I want to speak about the Supreme Court's decision they made earlier this year. If I think it's around May, they made a decision that they would no longer hear ineffective assistance of counsel cases that present new evidence. Now, this is a problem because if we look through the history of this conviction system, we've seen many cases where the police or the prosecutor withheld exculpatory evidence. Exculpatory evidence is evidence that's damaging to the prosecution's case, that can either get it dismissed or it can raise a substantial reasonable doubt. And they'll withhold it. They won't give it to the defense. And so when this was found out, that's a constitutional violation. So the case was overturned. People got out of prison. They got their lives back. With this decision the Supreme Court made, it takes the burden away from the police and the prosecutor and gives your defense attorney the green light to withhold evidence from you. In a criminal case, your defense attorney gets all the evidence in the case. So he could take stuff out before he even present it to you. That prevents the police and the prosecutor from having to keep it away, because in those cases where they was overturned based on new evidence, they didn't give it up to the defense. Now they can give it up to the defense, and defense itself can withhold it from you. So now they ain't liable. That's how they get over that hump of getting these cases overturned, because now we're going to have the defense attorney do it. And make sure there's no consequences for them when he do it. There's no remedy for this person after the defense attorney does it. Now, they say they don't want to undermine the state court's decisions. But there's two things I want to speak about that. First off, when a person is wrongly convicted and you file an appeal, the state court more than likely is not going to overturn it, because that makes the state liable. They have to pay when it's proven that there was unlawful acts that secured the conviction. They have to pay. So they're not going to overturn it. We had this problem with the states all the time. Every case that's been overturned, it's been overturned through the Supreme Court. The state courts don't want to overturn cases. They don't want to hold their prosecutors and their police accountable. We know this. So for the Supreme Court to say they don't want to undermine the authority of the state courts is nonsense. And I'm going to show you how they working together. I know myself went through this, where my attorney withheld evidence. The probable cause for my arrest was proven to be false in the dash cam video. Proven. My attorney never told me about this video, never presented this video in my defense. I found out about this video after he repeatedly told me there's no way he can win this case. And if I don't take this plea deal, I may end up getting 20 years. Repeatedly, after I told him I'm not taking no plea deal, he came back the next day, he needed to take a plea deal. I told him again I wasn't taking no plea deal, he came back the next day, spent hours down there to convince me that I need to take a plea deal or I will get 20 years. The whole time he had the video that would have literally got my case dismissed, because there was no probable cause, there's no case. But the thing about the probable cause is it was a lie, it was fabricated, it was presented to the court as fact. So now the people that presented that would be in trouble. The prosecutor would be in trouble for pursuing that case, knowing that probable cause was a lie. So once I found out about it, I present this information, I present my argument to the appeals court. The appeals court said that my attorney withholding evidence that could get my case dismissed was trial strategy. How my attorney withhold evidence that could get my case dismissed is trial strategy in my favor. It was trial strategy in the favor of the prosecution. That's a fact. You can see the evidence proves it beyond a reasonable doubt. No allegations. These are facts. The appeals court said that was trial strategy and that was not ineffective assistance of counsel. Regardless of the weight of the evidence. When you look at this evidence, it's like, oh yeah, there's no probable cause. So they say, damn my civil rights. They're my civil rights. We can see the probable cause is fake. It was a lie. The police made it up. But that don't matter. It don't matter. That's trial strategy for your defense attorney not to present that in your defense. This is what the state courts are doing in these cases. I got a homeboy in Georgia. Same thing happened to him. His lawyer withheld evidence that would have raised reasonable doubt against what the prosecution was saying. It would dispel some of the things that the witnesses said. It would prove that what they saying was a lie. And he didn't present that. And when he filed the appeal based on that, they said, oh, that's trial strategy. How can an appeals court uphold a strategy that's solely in the favor of a conviction? How can that be a defense strategy and be considered okay? When you can look at the weight of the evidence that the attorney withheld and seeing that if he would have presented the evidence, it literally got the case thrown out. And they say, oh, that's trial strategy. That's not ineffective assistance of counsel. This is what the states are doing now. So that ties into, now you go to try to appeal it to the Supreme Court, and they say, oh, we're not even going to hear it. It wasn't presented at trial, so we're not going to hear it. Any new evidence that wasn't presented at trial, they're not hearing it. The Supreme Court is literally giving defense attorneys the opportunity to railroad you, to withhold evidence that can get your case dismissed. The whole time your attorney telling you this is the best he could do, I can only get you this plea deal. Or just withhold it and make sure you get a guilty verdict at trial. And then when you found out about it and you appeal it and you present this evidence in your favor, the Supreme Court saying so you can prove that they lied. It don't matter. They ain't talk about it at trial. We not hearing it now. But that's the whole point of the prosecutor and the police getting evidence withheld to secure the conviction. That's why they partner with the defense attorney. I need you not to present that, man. I need this case. Okay. And he do it. And then you find out about it later. And the Supreme Court saying so. We ain't going to hear it. We don't care. They don't present it at trial. You don't get to use it in your defense in the Supreme Court. That's a fact. That's what they saying. But what's the whole point? The whole point of them withholding it at trial? It's obvious what they're doing. Now that, the brothers and sisters are exercising their civil rights, getting these bogus and unlawful convictions overturned, the Supreme Court is setting it up so that those unlawful convictions stand, y'all. They changing the game. Like every time we do something, we accomplish something, they move the bar. So they changing it. Just to secure convictions. They don't care about justice. They don't care about the truth. All they care about is locking us up. That's it. This system is designed to oppress us, man. We got to stop allowing these people to put handcuffs on us and lock us in their prison just because they want to. Just because of where we're from. Just because of the color of our skin. They feel like we don't have the right to defend ourselves against them. We don't have no right to dispute what they say. What they say is what it is, and no matter what, that's what it is. That's what's going on. They dead wrong and they know they wrong. But they create these laws and these policies to make us abide by it. And we don't have to. Fuck them. If you wrong, you wrong. You're not finna put handcuffs on me and run me through this courtroom knowing that y'all already got it set up for me to fail. Y'all got it set up to secure convictions. Fuck the truth. We don't care about the truth. Anything we say can and will be used against you. That's their first order of business when they arrest you. They say it in the Miranda rights. Anything you say can and will be used against you, not to seek justice, not to find the truth, but to be used against you. That's why they want to withhold evidence that could kill a case. They don't care. Oh, this evidence proved that he's not guilty. So what? Let's hide it. That's what they doing. In courtrooms all across this country, every day. It's happening right now to somebody. And the Supreme Court is supporting it.